Hey everyone, if you have an Airbnb or VRBO, you're going to want to watch this all the way to the end. It's an interview with a real estate attorney that specializes in property rights. He helped Jamie and I through this crazy experience we had with our very first Airbnb. We're going to get into the landmark case that he tried and went all the way to the Texas Supreme Court. They ended up deciding unanimously in the favor of his client, transforming real estate property rights for short-term rental owners in Texas. We'll talk about the other cases that are pending. They're going to have huge impacts on the short-term rental business in Texas and in other states. And then at the very end, Jamie's going to be joining me. We're going to go over that crazy experience we had with our first Airbnb. I'm talking neighbors with binoculars spying on us to threatening emails and phone calls and the neighbors all colluding against us. It was just nuts. So stay tuned to the end. You're going to enjoy it. Hey everyone. I'm very excited to be here today with this interview. It's a very interesting topic and a situation that my wife and I, Jamie, we're going to detail more at the end of the interview and do a lot of background into our experience with Airbnb. But through that experience, we got introduced to Mr. Patrick Sutton. He's with the law office of Patrick Sutton in Austin, Texas. He's handled civil appeal cases in the U.S. Supreme Court, Texas Supreme Court, Texas Intermediate Appellate Courts, and the Fifth Circuit U.S. Court of Appeals. Hope I got all that right. He's a real estate litigation and civil appeals attorney specializing in real estate and property rights disputes. To sum it all down, essentially, he represents kind of the little guy going toe-to-toe with big firms representing the cities, corporations, and with my specific case, HOAs or developers. So with that introduction, how you doing, Patrick?
Good, thank you. Thanks for having me this morning.
My pleasure. So to start off, this is probably the correct thing to do legally. This is a educational only podcast. There's no legal advice here. We don't know anything, or I'm not an attorney, he's the attorney. He doesn't know anything about your specific needs or situation. So if you need more advice on your specific case or issue, reach out to an attorney or reach out to him directly. So this is absolutely educational advice and for purposes only. I don't know if you got any other disclosures you want to add to that.
Yeah, I think you covered the bases.
All right. So May 25th, 2018, the Supreme Court of Texas makes a decision, and it's a decision that you're involved in. Tarr versus Timberwood Park. You're representing Mr. Tarr, and the Supreme Court decided unanimously in favor of your client. So this is something we stumbled across this case when we had an issue with a developer up for an Airbnb that we had, and my wife was doing some searching and she found this case. I'm like, and I read the whole summary. I'm like, holy cow! This is like, for the most part, very similar to the situation we're going through. And I was like, this is landmark in Texas, and most people don't know about it. So what makes the Tarr versus Timberwood Park a landmark case for Texas property owners that are using their properties for short-term rentals?
Well, you're correct, Chris, that it is, first of all, it's landmark. Second, it is not widely appreciated. And I am still getting calls from people who say, I just got a letter from my HOA saying I can't rent for short terms. And when I read the HOA's reasoning, it's clear they have not seen the Tarr opinion and have not consulted an attorney. So Ken Tarr and his wife, like many people, have deed restrictions that say you can only use your house for residential purposes, and you can't run a business out of the house. Well, that's not surprising. Nobody thinks you can operate a gas station or a convenience store or something from your house. But what people who don't like short-term rentals are saying is that your house is a business just because someone stays there less than 30 days. So there's some magic, or sometimes they say 90 days. They don't always give the same answer, but there's some magic number of days that converts a house from residential to business. So what the Supreme Court said in Tarr is, first of all, a short-term rental is just a rental. You're not talking about anything different. The fact that someone is there for 29 days versus 31 days has nothing to do with the fact, or has nothing to do with whether the way the people live in the house is residential. So that's the first and probably most important thing. That is, residential encompasses short-term rentals. They're not a business. The second most important thing, and this is where you'll see Tarr over the years, I think, really get steam, is that it said when deed restrictions are silent about something, that doesn't mean that that something is restricted. So what the HOA in Tarr was arguing is that because the deed restrictions say nothing at all about the duration of time that someone can stay in a property, that somehow that's a ban on what the HOA called transient use. So they use this word transient to suggest that drifters and hobos and dangerous people are staying in houses, and you see that all the time. But the Supreme Court said, no, there's nothing, we're not going to read into a set of restrictive covenants, which almost everyone has, some new word that you think the drafter left out. So silence is not a restriction.
Yeah, so essentially added definition and clarity to what a clause that, from what I understand, most HOAs and communities have, that a property is a residence is for residential use and not for commercial use. They have very similar verbiage. I looked at my personal residence and the Airbnb that we had the dispute with, and it was almost verbatim the exact same language. But what this case did was added clarity to the definition of what residential use and commercial use is. And a rental is residential use. And then it just went that extra step, like read the briefing. It's so, I can nerd out on it a little bit, but it said that the use of it as a rental, even if it's short term, does not constitute that is a business. So it was a two-pronged approach that I think it was like a 1-2 punch against the HOAs, that at least against Timberwood Park, on what your client was really doing, which was he's got a residence. He's just trying to rent it out, regardless of how long it is.
Well, right. And people in their lives have all sorts of reasons for needing to rent out a property for short terms. And the attempt to demonize short-term rentals always uses formulations like transient or vacation to make it seem like it's something that it's not. But as you say, it's just an ordinary rental. At the oral argument in the Supreme Court, the Chief Justice asked me the question, well, Mr. Sutton, what if Mr. Tarr set up a real estate office in the back of the house and, had employees and people coming and going to sign leases? Would that constitute a business use? Well, the answer is of course. I mean, that's not different than setting up any other kind of business in your house. Now, it's a separate question whether people doing home occupations, can still do that. And that's a different set of issues that we can get into. But if I'm asked the question, if you set up a real estate office as a business, of course. But that's not what happens with short-term rentals, right? People list them on the web. Usually the landlord, is not at the house, doesn't typically greet the people. There are no transactions happening. From day to day, it's just people coming and going from a house the way that people ordinarily come and go from a house. And that's what one of the other justices pointed out at the oral argument. What is different about what people are doing with a short-term rental as compared to a long-term rental? And I can talk to you about some of the newer arguments I'm hearing. People are still bringing challenges on residential use, but that's the nut of the issue.
Yeah, and I think a lot of it stems from it's new. I mean, it's not really new. It's just technology has allowed platforms to allow it to become more widespread. So, but most people, especially communities, are uneducated on what it is. And I make the argument that a short-term rental in most cases is better than the long-term rental, because we have both short-term and long-term rentals. And whenever I'm getting a long-term rental ready to go in the market, it's going to be in its best shape possible. I'll get the most rent, the best tenants. It makes sense. But that's it. I'm not going to do anything else other than maintaining the safety and then the integrity of the property. But the overall maintenance is on the tenant, how frequently they mow the yard and do the shrubs and all that stuff. That's on them. But a short-term rental, they have to maintain on a very frequent basis, whether it's every few days, a few times a week, or a couple times a month, to make sure that property is in tip-top shape all the time. Because if they don't, they're going to get crushed in reviews. They're going to lose any rental revenue that they would have, or at least they won't maximize on that. And from a competitive standpoint, other ones, other rentals are they're going to take their customers. So I argue that with a little education, like, it's actually good. It's better than the long-term rental.
Well, wow, you touched on a lot of subjects. So let me address a couple of those. In the lawsuits, typically the people who oppose STRs say that it reduces property values. But then when we really look at this more closely, we find that if you evaluate a short-term rental based on a rental income stream, plainly it increases the value of that house. And there are some cases now pointing out that it increases values overall, partly for the reasons you've just identified. You absolutely have to keep that house in good shape. But let's talk about the kind of ugly underside of short-term rentals. So there's what people say, the reason that, here's why we don't want short-term rentals, and then there's what they mean.
Mm-hmm.
So on the witness stand, they'll say, we don't want strangers coming into our neighborhood. There are people we don't know driving on the streets. The people are different from week to week or month to month. That's a code. And you can take a stab at what you think the code is, but there are various indications what people might be thinking. For instance, an HOA up in North Texas just amended its deed restrictions to not only ban short-term rentals, but to ban rentals to anyone who has ever had a felony conviction. That is 1/3 of the adult population of the United States. And that is blatantly discriminatory under the Fair Housing Act, in my legal opinion. I have not been asked to litigate one of those cases, but to say that anyone who, when they were 25 years old, had some sort of a felony conviction and now they're 50 and can't rent a house is insane. Now, I will leave it open to you. What do you think people mean when they say that we don't want strangers or we don't want people who've ever had a felony conviction?
Yeah, it's who knows, but there is a lot of push both from the federal government, HUD, and Housing Authority, and then local governments and states on that discriminatory thing. Even I think Austin, you may know better than me, I think the city of Austin, I don't know if it actually happened, but they were trying to put restrictions on how you could restrict people from getting like housing or Section 8 or stuff like that, all leaning back on the discrimination, because there's one thing the government will not tolerate, and that's housing discrimination. And if you get caught with it, like, it's bad news.
Well, the federal government doesn't like it, but local governments seem more than willing to do it under another guise, like short-term rental regulation. And I don't want to get too political in this podcast, but I have seen the dark underside of some of these cases, and I can assure you that there are people with bad intent who are seeking to bar short-term rentals really for reasons having nothing to do with the value of the homes or even the duration issue at all. It's just another way of discriminating in housing.
I believe it, sad. So how should homeowners respond to an aggressive HOA, like assuming that they feel that the definition in Tarr versus Timberwood is similar to their own? How should they respond to an aggressive HOA demanding that they stop the short-term rental?
Well, it's a tough choice, and here's why. Texas law has a quirk that is sort of blatantly anti-homeowner. And it is that if someone sues you for breach of your restrictive covenants, but you prevail, you don't get to collect your attorney's fees against that HOA for prevailing. And yet, if you had sued first, simply to have your right to rent for short terms declared proper, if you prevailed, you could get your attorney's fees. So this creates a race to the courthouse situation, where if you don't take the threat seriously from the HOA and they go off half-cocked and file a lawsuit, even though Tarr would prevent them from winning, you might have to pay thousands of dollars ultimately to get that suit dismissed but you still won't get to collect your attorney's fees. So what choices does a homeowner have? Well, file that preemptive suit so that you can preserve the claim for attorney's fees. That's a frightening proposition for a lot of people. The other option is to send the HOA a letter saying, look, we got your letter saying that leasing is a business use, but the Tarr against Timberwood Park says that's wrong, and we demand that you withdraw your cease and desist letter. Generally speaking, when I send out letters like that, I'm seeing a letter back after the HOA retains an attorney, and the HOA says, you got us. We withdraw the letter, but not always. And there are people with economic resources who've just decided that despite the fact that Tarr means what it says, they're going to sue anyway. They know they get the jump on homeowners by suing first, so the homeowner can't collect fees and has to pay a lot to defend the suit. So people face a difficult choice up front, whether to send a letter or just file the lawsuit to protect their rights.
And that was the dilemma we were in, and we felt strongly on our position, but it's a path of, do we want to commit towards something that may end up costing us tens, $100,000 if it runs the full length, like the worst case scenario, or wait for them to shoot first. And we were kind of in that dilemma, and ultimately we decided to just stop renting because we were going to just sell the property. But then we still got petitioned. They withdrew that, and I'm going to go over that more whenever I summarize. We'll go over all the details. But so if homeowners decide to shoot first, do that preemptive, actually, I'll say this, because this is what happened. We sent them the briefing. I actually copied and pasted the bottom couple paragraphs that summarize the entire thing. And at that point, they responded back with something with the effect of, this has been forwarded to counsel. Essentially, they said, we're going to let our attorneys handle it from now on. And it was a big middle finger, really. And they didn't let up their position one bit. But 2 months later, they send us an amendment saying, hey, look, I viewed it as, you're right. We're just going to change the rules on you. And they sent us an amendment to the deed restrictions. And this was not an HOA, it was a developer. They sent an amendment. They had our neighbors and a whole bunch of other people to get the majority they needed to do the amendment. And they said, okay, here you go. Don't do it again. And then, of course, when we did, that's when we got more demand letters and then finally a petition. So can HOAs really do that?
Well, you've asked a question that is central to 7 lawsuits that I've filed in the last few months. I think we'll be seeking to have all those combined into one court through a special procedure here in Texas called multi-district litigation. I expect to file 5 or 10 more of those cases in the next year. So the response by HOAs and subdivision owners to Tarr, when they realize that they can't just say short-term rentals are not allowed because they're not residential, is they say, fine, let's get together our majority or supermajority and amend the restrictions to say that short-term rentals are not allowed. Now, I'm going to pose some hypotheticals for you of the type that I've been posing in these cases. I can tell you in one case, a judge in Houston that was looking at one of these cases, when he heard the hypotheticals and then had some of his own, was extremely troubled by the idea that an amendment can immediately take away your rights. So here's one example. A young couple buys a lot in a subdivision with plans to build, and the deed restrictions say all houses must be a minimum of 1,000 square feet. This is a very common example. Well, their new neighbors don't like the look of this young couple. So the neighbors get together and adopt by a majority vote an amendment which says the minimum size for all new houses is 3,000 square feet. So let's just say this happens a month after this couple purchases that lot. So what they bought has just been taken away. The right to build a small house on their lot that they could afford to build has been taken from them. Is that enforceable? That's one example. Let's take an example of a family that loves horses. So they buy just outside the Austin city limits. And again, a real common example, a 3 to 5 acre, a house on 3 to 5 acres. And they proceed to get a couple of horses and build a barn. Well, the new neighbors decide they don't like the smell. They don't like the look of a barn. So they get together and adopt an amendment which bars horses in barns. Is that enforceable? I could spin out example after example. Actually, a terrific one that I just saw, in one of these new cases, is the amendment to bar short-term rentals also says that the board, that is 3 people sitting on the board, can unilaterally decide that 90% of all the homes cannot lease, that only 10% can. In essence, they've just wiped out all leasing rights. Are any of these enforceable against people who purchased without notice? And so here's how that shakes out. We have about 10 states that have addressed this, have said something like, if you looked at the original restrictions and there's no hint that a particular subject could later get restricted, then it is not fair to enforce a new restriction against people who purchased under the prior restrictions. Texas has not squarely addressed quite that set of facts. 2 other states have said an amendment clause means what it says. When you bought your property, you knew the deed restrictions could be amended. Therefore, anything goes. If your neighbors decide it's banned immediately. In Texas, the cases have said, in essence, an amendment can give you new rights. That is, it can take away restrictions. But what we haven't had is that case where a right was plainly just taken away. And so, I'm bringing the first batch of these cases all over the state. We've had one trial in Houston. I expect to have another one shortly in Austin. I'm hoping a bunch of them get consolidated into one case. This is a big issue, because if neighborhoods cannot immediately ban short-term rentals where people who purchased premised on that right want to continue, then what you'll see is a gradual turnover, so that deed restrictions will become effective as new buyers come in. You won't have this abrupt cutting off of property rights. I'm hopeful, but this is an area of new law we're making.
And I'm really excited to see how those cases turn out. The gradual approach or transition, as you mentioned, I think that would be good, because it would also add, this is an extra value proposition for homeowners now to consider when they're moving into a neighborhood. And we get the question, hey, can we Airbnb it? We sell a lot of houses. Can we Airbnb in this neighborhood? If that question is answered yes or no, it's going to start making decisions, certain decisions on the buyers, and ultimately could increase or decrease property values in those neighborhoods, which is fine. If you know up front you can't, then you were warned. But to specifically target, as we were, an individual homeowner just because you didn't like them or the people that they had in there, I just feel that that's not right. It's unfortunate. All right, so if anyone has any issues like this or similar, or some other real estate right dispute, how should they reach out to you?
Oh, well, fortunately, I'm easy to find on the web, just because this is such a hot button topic. So if you type in Patrick Sutton Austin, you'll come up with my law firm site. And I have a lot of information about these cases. It's actually a real website with real opinions and information on the cases I handle. And it's not just a bunch of a list of accolades that I've received, because I haven't. I'm usually in the crosshairs. I don't get too many accolades for suing corporations and homeowners associations.
All right, yeah, we'll put that in the show notes along with the briefing or the summary of Tarr versus Timberwood. I've recommended this case. Hey, go read this thing. You need to really look at it and see how it applies to your situation. So, Mr. Sutton, it's been a pleasure. Wish you luck in defending these rights for homeowners across Texas. And absolutely, I just appreciate it.
Oh, this is a lot of fun. Thanks for having me this morning.
All right, welcome to our Airbnb horror story.
Chronicles.
Yeah, the Chronicles. So this is a property that we actually didn't want. It was like an hour and a half away from us. They found us from on the internet. And long story short, we gave the seller an ultimatum because it was a beautiful property. We were like, hey, look, yeah, that's a lot of work. 20 grand off of what we had it on contract or owner's financing. I wanted them to take the owner's financing. She took the 20 grand off. They really wanted out. So I'm like, all right, babe, I guess we're buying a lake house. And so we ended up buying it, doing this like $75,000 remodel, beautiful, put it on the market. And
lake view. You go out in the backyard, it's the lake.
Yeah,
gorgeous house.
In a very secluded,
prestigious neighborhood. Yeah.
Yeah, and then full sunset dock, boat house, boat house, and boat lift and storage, just absolutely amazing.
Mm-hmm.
So we put it on the market, knowing that it was probably gonna take a little while to sell.
Right.
Which it did, and actually we didn't really get any traction at the time. So we're like, hey,
like with any investment, when it sits for a while, you try to look for other exit strategies. So that's kind of what we did.
Because it's prestigious location, and a lot of our friends were just killing it with Airbnb. That was what we decided to do. It was like, hey, this is a cool location. This is like a great vacation spot. Let's test out this whole Airbnb thing.
Yep.
So our very first Airbnb became our Airbnb from hell.
Yeah, it really was. And but anyway, we decided to move forward with it. I went in. I manage our Airbnb, so I was able to set that house up in a week. Luckily, we bought the staging furniture from our stager.
Because we were trying to beat Memorial Day.
Yeah. And I remember our first guest, actually, all the furniture wasn't even there. There wasn't even a refrigerator. And he just got a heck of a deal.
Because we didn't know about the instant booking on Airbnb.
Instant booking.
Like, oh man, like someone booked.
Yeah, I know. And we really wanted to get that superhost status. It was a learning curve. This whole situation was a complete learning curve. Like how to use Airbnb. We just dove headfirst in. And I remember before asking Chris, I said, hey, are you sure we can Airbnb this place? And I remember looking at the deed, and I had him looking at the deed restrictions just to verify, because I said, I don't want to do all this because I'm such a rule follower. So I just want to make sure that we can do this. And
so yeah,
I looked it up and
I didn't see anything that restricted it.
Yeah,
and
they didn't even have an active HOA either. It was just the deed restrictions that we were given at closing.
Yeah, it was basically developer managed, and that was big. There was no HOA. Deed restrictions didn't forbid it. So it was all good to me.
Right.
So we put it on Airbnb. She's managing this thing, and like in a very short time, we had like over $8,000 in bookings.
Just for that summer, yeah.
Yeah, it was like 2.5 months, and on top of that, the first month and a half, like we had priced that thing ridiculously lower than what we should have.
Right.
We're
just learning how to.
For a 3,000 square foot luxury house, fully stocked, with a boat house and ramp and all that stuff.
It should have been like 150 or something, but I think it was like 75 some nights. It was ridiculous. Don't do it. Don't do that.
Well, we didn't know,
and your high price also screens your guests. I mean, the higher the price.
Which maybe that would have screened the guest that kind of was the first domino to fall.
That was the reason why. Because at one point, some guests that stayed there, it was like a frat house. I'm not even kidding you. We had a camera, a Ring doorbell camera, that's all. And there were about 13 college students who stayed. Nice. So that was kind of a red flag. And then what really got the developers' attention was there's an empty lot next door to us, which is the developer's land, and some of the kids from these other guests, different guests, were just playing soccer. And so Chris got a call.
Well, they called the realtor, so we had to
because we had it listed still. We still had this listed. We had every intention on selling this property. We were just trying to make money, those high interest rates for
cover
short-term loans.
expenses. So the realtor calls me and say, hey, look, like the developer called and he's like cussing me out saying that renters aren't allowed and they better get out of there immediately. And they were on his vacant lot. And I mean, this is a vacant lot. Was mowed like once every other month and trees, and otherwise there was nothing there. Right. I'm like, okay. So I ended up pulling the call, and he was a little overboard. And so I call him, he didn't answer. So I shoot him an email just saying, hey, sorry, like they shouldn't have been over there. We'll make sure that never happens again. And don't worry, they're not long-term rentals. They're renters. They'll be gone tomorrow. And that was it. So he promptly replied back, clarifying what he was really trying to tell me is, no short-term renters or guests or anything of the kind are allowed. They're strictly prohibited in the deed restrictions, and I need to review them. And then he sent me a copy.
Remove them. You need to remove them.
Well, I need to get rid of the tenants and then review the restrictions. Then he sends me a copy of the restrictions, and it was the same copy I already looked at. And so I replied back just saying, hey, totally understand. Yeah, they're going to be gone tomorrow, and we don't have any long-term tenants. I kind of restate the position, and he basically makes it even clearer. He goes, I hope I've been clear on this, and he restates that no, you better not have any short-term tenants there at all.
So anyway, I know that rattled you where you wanted to fight it, but with me, I'm like, wait, I want to make sure we're in the right here. So the rule follower that I am, I remember hearing other stories about homeowners battling the HOA because of Airbnb. So I actually looked up online to see if there were any court cases or if it went to court. And I actually found one, and it was in Texas. It was Tarr versus Timberwood. So I get all that, I kind of read through it, and I'm like, hey, and they ruled in favor of the homeowner. So I, showed that to Chris, and, I let Chris do the work of emailing.
Yeah, that's when I reached out to Patrick Sutton, and because the case, even though that wasn't with an HOA, other than that, it was basically almost identical to what we were going through. Mm-hmm. So I reach out to him, and he's just like, okay, well, why don't you just send him the last couple of paragraphs of the summary and see how they respond to that. So I wait, and they eventually send us a formal letter from. No. So I send that to the developer. I send him the last couple of paragraphs of the Tarr versus Timberwood summary.
No, we didn't hear from him.
But no, he replied very promptly, saying your response will be forwarded to counsel for disposition.
Right.
Basically, you're saying we're going to sue you.
Uh-huh.
And then a couple weeks later, we get a formal letter from the attorney. It was basically a cease and desist letter telling us to stop, and what we're doing is forbidden. And so we're like, I send that over to the attorney, and then that's when we have a real conversation about what our options are with the attorney. And it basically boiled down to, we can wait and be sued, or we can sue first, or we can just stop altogether. And like, none of them were good options, because if we sued and went regardless, if we went the entire distance through a lawsuit, it was going to cost us about $100,000. Mm-hmm. The advantages of suing first was we potentially could get our attorney's fees back, which is what Tarr did. He got his attorney's fees back when he won. But in Texas, if you are sued, if you're the defendant, even if you win, you can't recoup your attorney's fees. So we're in that dilemma, and then of course, if we just stop altogether, like we'd have to cancel bookings, and then
lose my superhost status, and then we didn't want to do that.
It's $3,000 a month just holding this place, and it never made sense to hold unless we could cash flow it from rentals.
Right.
Otherwise, we have to sell it, and if we put it on the market, we just didn't know how long it would take to sell. Because really, the only one buying this type of home it's a second home for like a doctor or an attorney or someone, or it's a retirement home.
Right.
Yeah, well, we ended up, I think, canceling like one Airbnb.
Right. Well, we didn't hear from the guy after we sent that, and once he said, I'm going to send it to my lawyers or whatever, I think it took about 30 days, maybe 2 months. We didn't actually hear from him. So we're like, hey, maybe we got off the hook. No. But what we found out he was doing was he gathered all of the neighbors, the same neighbors who, when we moved in, shook our hands, were so nice to our face. And then it just kind of went downhill after that. But he got them to sign something to just basically amend the deed restrictions to then state no short-term rentals were allowed.
Yeah, nothing less than like 90 days.
Right.
So which just kills any type of short-term rental.
Right.
And it was very specifically stated that. And that's when we realized, like, we're on these email chains and they're sending, like, things get weird. Yeah. Like, we're getting on email chains. We didn't know who all these other people were on the email. We later found out they were our neighbors. And then, of course, the attorney. Mm-hmm. But we're getting pictures.
Yes, my guests are texting me that the neighbors are taking pictures of them. And, I mean, whenever we go out, we notice them. Because, I mean, I have a huge family. So we've been going out there like every weekend we could get because it's an awesome lake house. So, and we noticed that, you know, the neighbors behind us were taking pictures. I swear he had like a corkboard in his office or something because he was a retired guy. I don't know if he had nothing better to do. And he was documenting all of the license plates or something. He had a great bird's eye view of all of our license plates. So we were getting pictures taken. One of the guests he was fishing and his line got stuck and he had to step into the neighbor's yard to unhook that line. And the neighbors came running out, taking a picture. Another time, I mean, it was just plain harassment. And a lot of the times, I mean, we stopped Airbnb-ing this property in August. So it was from August 2019 to April 2020 when we ultimately sold it, when we were still getting harassed by these neighbors and
from us
pictures,
and
our friends, because we were letting our friends, if we couldn't Airbnb it.
Yeah, one of them, he was fishing. He was like, they were driving their jet skis like really close to the dock, just totally like staring them down. And then even I was staying there once with my friends and
at the campfire, y'all.
Like, we were just drinking beer with buddies. And then you see them by the door, their little silhouette with their binoculars.
It was ridiculous. So ultimately, it came down to like, do we want to deal with this anymore? You know,
I was ready to fight. I really was.
Yeah.
I know.
I was not. I really wanted to crawl in a hole. But so we basically decided to relist it that spring of 2020. So I think it was February of 2020. We relisted it and ultimately got an offer in April.
Well, so we listed in February, got the offer in March, and we closed in April. So it actually happened really fast. We weren't expecting it. It was a total blessing from God.
Yeah.
But yeah, so now it's at this point, it was like, we know we're going to sell this thing and let's just enjoy it. A lot of time we're letting our close friends go out there and then boom, we get a lawsuit.
Yeah. I mean, every weekend we just like go over there. All of our friends, nobody was paying us anything. I mean, just for the cleaning fees and stuff like that. But everybody was out there.
Yeah. So
enjoying themselves.
I get a petition. I've got, I don't know, 30 days to respond or whatever. So I call the developer. I'm like, hey, so I got the petition. We're not renting it out. I'm not really sure what's going on. And then he's like, well, I'm not there, but all the neighbors are saying that there's multiple vehicles there and that it looks like you're renting. I'm like, yeah, our friends are coming over and we can do that. They're coming over. They're not tenants. And we're going to continue to do that until we sell. Mm-hmm. And he's like, well, I'll send that to me in an email and I'll have the attorneys work on something.
Yeah, and the listing was still showing up. Like, even though we hid the listing, they could still find the listing. And you can probably still find the listing to this day. I don't really know how to delete that. We've tried so many times. We've just hid it and turned it off.
Yeah,
so they kept saying that we were renting it because they saw the listing. But
ultimately they ended up sending like the settlement statement. It basically said, hey, you're never going to Airbnb it again. You're going to remove any type of advertisements for any type of short-term rental. And then on top of that, you're going to let your buyer know that they can't. You're going to give them a copy of the amended deed restrictions and serve them, let them know about this situation. That's basically what he was doing. It was a huge middle finger. We waited until the last moment to sign that petition because we want to make sure the sale was going to go through.
Right.
And protect our rights. Like, if we had to fight, we want to make sure we still could.
Right, exactly. So ultimately it came down. I mean, that was honestly a blessing getting that offer from that buyer because I sure as heck did not want to go through and fight this. And it really came down to like, is it worth your time? Is it worth the energy? Because this was a huge headache for us. It was stressful on me. I was managing the Airbnb and dealing with, all of that. And then, whenever our friends would go, I was still dealing with the headache of the neighbors. And yeah, we could have kept it for ourselves, but do we really want to live in a neighborhood like that with those neighbors? No. So long story short, do we want to, pay the $100,000 in legal fees or walk away with 70 grand in profit if we sell it? And, ultimately the 70 grand looked mighty shiny to us. And that's what we took. And, we have another lake house over there. We can buy another lake house just like that other one down the road. So if you ever choose, I guess our main point of all this is just sharing this because there's not many case studies out there. So we really wanted to kind of share our experience and really line out all of our options and what they were. And it just came down to it. It was just not worth our time and energy. And so sometimes those things you just need to bite the bullet and just walk away. And we walked away ahead. We didn't have to slash the price to sell it fast. We were just very lucky and we were able to walk away with a great profit, which was our intention all along when we first bought this property.
Yeah.
So, it was a headache. We wanted to keep it for ourselves and still Airbnb it, but that just wasn't the case for this property. That guy was not going to let up the developer.
Straight up a-hole. All right. Well, hope you enjoyed this story and the interview and
learn from it.
Learn from it and find some Airbnbs in the community that will appreciate you.
Yeah.
Thanks.